Akash.
Hello, sir.
Hello, sir. Mahesh sir ಆಗ್ಲೇ ಬಂದಿದ್ದಾರೆ, ಅವರನ್ನ ಅಪ್ರೂವ್ ಮಾಡಿ ಸರ್.
Yeah, sure.
ಎಷ್ಟೊತ್ತಿ ಸರ್ ನಿಮಗೆ ಕಾಲ್ ಮಾಡೋದು? ಎರಡೆರಡು ಇವಾಗ ನಿಮ್ಮ ತಾಯಿ ಕಾಲ್ ಮಾಡ್ತಾ ಇದ್ದೆ.
ಮೋಸ್ಟ್ಲಿ ಸೈಲೆಂಟ್ ಅಲ್ಲಿ ಇತ್ತ ಅಂತ.
Hi.
Good evening, sir.
Good evening, Vikram and Akash.
Good evening, sir.
Good evening. So, voice ಎಲ್ಲ ಸರಿಯಾಗಿ ಬರ್ತಾ ಇದೆಯಾ?
ಎಲ್ಲ
Yeah, correct
ಕರೆಕ್ಟ್ ಆಗಿದೆ
ಆಗಿದೆ,
ಸರ್.
Okay. So, shall I log in after 20-15 minutes?
What you can do is you can just mute your line and you can also switch off your video. ಹೀಗೆ ಬಿಟ್ಬಿಟ್ಟಿರಿ ಸರ್. ಆಮೇಲಿಂದ ನೀವು 55 ಗೆ you can join us.
All right. ಈಗ ಹಾಗೆ ಬಿಟ್ಟಿರ್ತೇನೆ. Then I will. But otherwise, my voice is clear ಅಲ್ಲ?
ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ವಾಯ್ಸ್ ಅಲ್ಲಿ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಸರ್, ಕರೆಕ್ಟ್ ಆಗಿದೆ.
Even video is also fine.
Yeah.
Distance, audio, video, everything is perfect. So
Fair
what you can do is you can just mute your line and you can also switch off the video. ಅದೆರಡನ್ನು ಮಾಡ್ಬಿಡಿ. ಅಲ್ಲೇ ಆಪ್ಷನ್ ಇರುತ್ತೆ ಕೆಳಗಡೆ, ಅದನ್ನ ಮಾಡಿದ್ರೆ.
Yeah, done.
So 5:55 you can come back, sir. You can take a quick break for 20 minutes.
Okay, fine. Yeah, thank you.
Okay, sir. Thank you. ಆಕಾಶ್, ಬೇರೆಯವ್ರನ್ನೆಲ್ಲ ಪ್ಯಾನಲ್ ಎಲ್ಲ ಆಡ್ ಮಾಡ್ತಾ ಇರಿ, ಹಂಗೆ ಜಾಯಿನ್ ಆದವ್ರನ್ನ.
Sure.
ಆಗಿದಾರ ಯಾರು?
ಆಗಿದ್ದಾರೆ. ಗುಪ್ತಾ ಸರ್ ಮತ್ತೆ
ಆಗಿದ್ದಾರೆ.
ಇನ್ನೊಬ್ರು ಯಾರೋ ಆಗಿದ್ದಾರೆ.
ನಮ್ ಹರ್ಷ ಆಗಿದ್ದಾರೆ.
Yes.
Good morning, sir. Good evening, sir. Good evening, sir.
ಹಲೋ ಸರ್,
ಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ ಸರ್? ಸರ್, I want after session is over, I want to ask some questions. That's why I want my name should be registered, sir. I am Advocate Ishwar Nayak.
ಸರ್, ತಾವು ದಯವಿಟ್ಟು ಕ್ವಶನ್ ಕೇಳ್ಬಹುದು. ಕ್ಯೂ ಅಂಡ್ ಎ ಸೆಷನ್ ಸ್ಟಾರ್ಟ್ ಆದಾಗ ತಾವು ಹ್ಯಾಂಡ್ ರೈಸ್ ಮಾಡ್ಬೋದು, ನೀವು ಕ್ವಶನ್ ಕೇಳ್ಬಹುದು. ಆಕಾಶ್, ನಿಮಗೆ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ನಾನು ಹೇಳ್ತಾ ಇರೋದು? ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ನೀವು. ಕೇಳಿಸ್ತಾ ಇದೆ ಅಲ್ವಾ ಸರ್? ಎಲ್ಲಾ ವ್ಯೂವರ್ಸ್ ನಾವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ತೀವಿ ಕ್ಯೂ ಅಂಡ್ ಎ ಸೆಷನ್ ಸ್ಟಾರ್ಟ್ ಆದಾಗ. ಅವಾಗ ಯಾರಿಗೆ ಕ್ವಶನ್ ಇರುತ್ತೆ ತಾವು ಸ್ಪೀಕರ್ ನ ಕೇಳ್ಬೋದು. ಈಶ್ವರ್ ನಾಯಕ್ ಅವ್ರು ಬಂದಿದ್ರು, ಅವ್ರು ಕೇಳಿದ್ರು, ನಂದು ಮ್ಯೂಟ್ ಆಗಿತ್ತು ಆ ಟೈಮ್ ಅಲ್ಲಿ. ಸೊ ಜಸ್ಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ. You can go live in 2 minutes, Akash.
Yeah, I'll prepare myself now. I'll go live by 5:56.
5:56, yes. ವಾಟ್ಸಪ್ ಚೆಕ್ ಮಾಡ್ಬಿಡಿ ಆಕಾಶ್ ಒಂದ್ಸತಿ.
Yes sir, we are on live now.
We are live. It is 5:56. Mahesh sir is also ready, but we will start the session by 6 o'clock. Is that fine, sir?
Yeah, sure with me.
Thank you.
Sir, I'll make you as a host and I'll be on
No
mute.
problem. No problem. Yes.
Okay. So I think you are the host now. You got it?
Let me just check if I've got the options. Yes, I am the host. Thank you.
So I have disabled the unmute option in the.
All right.
Okay, you check and let the people unmute
All
themselves.
right. All right. All right. All right.
Okay, thanks a lot, sir.
No
Thank you,
problem.
Akash.
Thank you. Sir, it is 6 o'clock. Can we start the session, sir?
Sure, I'm ready.
Thank you, sir.
Welcome. Yes.
Good evening, a warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today founder partner of Mahesh and Co, Mr. S. Mahesh, Advocate High Court of Karnataka. Sir, we are elated to have you with us. Welcome to the webinar, sir.
Thank
With
you.
immense pleasure, I would now like to introduce our today's speaker. Mr. S. Mahesh enrolled as an advocate in the year 1991. He joined the office of Sri R.B. Deshpande, who had roaring practice in the High Court ever since the days of his renowned father, late Sri B.V. Deshpande. Mr. Mahesh has appeared in trial courts and gained expertise on the trial aspects. He has worked on the appellate side in the High Court and is well versed with the High Court practice. Mr. Mahesh has served as a special public prosecutor for the Enforcement Directorate from the year 2001 to 2018, handling cases pertaining to FERA and PMLA for both cases in trial and High Court. Along with practice on the criminal law, Mr. Mahesh has practiced on the civil law before the trial courts, High Court, and even Supreme Court of India. Recently, he has appeared for monthly developers before the National Green Tribunal in a case where Rajakalwe was considered. He also takes the credit of conducting the trial on behalf of a French national who was the accused and the case got acquitted. He has appeared for Karnataka Biotechnology and Information Technology Services, KBITS. He has also appeared for builders like Mantri, Embassy, Century, Renaissance, among others, and he is also exposed to the real estate litigation. He has also appeared on behalf of several reputed companies such as Unilever, Coca-Cola, Reliance Communication, LG Electronics, to name a few. Mr. Mahesh was also appointed as a special public prosecutor to conduct case on behalf of the prosecution in offences relating to POCSO. Sir, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you, sir. Over to you.
Thank you very much, Mr. Trivikram. Good evening, everyone. Hope all of you and your family are keeping good health. Friends, for any professional, technical knowledge of a subject is of paramount importance. More so, for law practitioners like us, it is imperative. Everyday law evolves, and it is our duty to be in sync with it. After some point of time in our profession, we tend to become complacent in the matter of learning. We seek only that much of knowledge that is required for our day-to-day practice, unaware of the development in other field of law. Of course, I would say that time is also a culprit. Now, in view of COVID, though it is undesirable, we have time and we can utilize this time to upgrade our legal skills and technical knowledge. It is here I compliment our Advocates Association, its office bearers, Mr. Ranganath, Mr. Devendrappa, Rajshekhar, for having taken keen interest and has initiated these webinar sessions. In fact, they have invited some of the wonderful law scholars from our bar as well as across, who have imparted their knowledge and shared their experiences. This has been a great learning experience for a law student like me, which otherwise probably I would not even know about many aspects of law in other fields. I also thank Mr. Trivikram and his team for having taken such a good interest, wonderful interest, chasing us, ensuring that we are here on time and with their subjects. So I thank you, Mr. Trivikram and his team as well. I also thank Advocates Association for inviting me for today's session. I am privileged to be amongst you in this session. Today, I would like to share an overview of the type of witnesses we encounter in the trial, more so in a criminal trial. Now let us see where our witnesses fit in. In criminal trial, as you are aware, corroboration of a fact is a must and cannot be dispensed with. More so in a criminal trial, even admitted facts need to be proved and corroborated. For that, evidence of witness is required. Whether his witness is direct or circumstantial, it doesn't matter. But witness is a must. Noted English jurist, Mr. Jeremy Bentham has said, witnesses are the eyes and ears of justice. In fact, these words have been used by the Honorable Supreme Court on several occasions. This is the importance of witnesses in the administration of justice. Our Honorable Supreme Court, in the case of Swaran Singh versus State of Punjab, reported in the year 2000 Criminal Journal at para 37, has held that a criminal case is built on the edifice of evidence, evidence that is admissible in law. For that, witnesses are required, whether it is direct evidence or circumstantial evidence. So, the role of witnesses is extremely necessary and important in the criminal jurisprudence. And as per our criminal jurisprudence, as you are all aware, an accused is presumed to be innocent till proven guilty. In fact, the prosecution has a onerous task of proving his case against the accused beyond all reasonable doubt by producing cogent and reliable evidence in the trial. In fact, to satisfy all these requirements of criminal jurisprudence, production of evidence by way of testimony of witnesses is crucial. As you are aware, without witness, there cannot be any trial, especially in the criminal cases. Now let us see briefly what is evidence under Evidence Act so as to fit in our witnesses. Section 3 of the Evidence Act defines the term evidence. Evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to the matters of fact under inquiry. Second, all documents, including electronic records, produced for the inspection of the court. Such documents are called documentary evidence. Friends, as you see from this definition, at the first blush, it appears that there are only two forms of evidence. That is the statement of witnesses and documents relating to electronic records. Sorry, including electronic records. But however, if you closely notice, Section 3 opens with the words, evidence means and includes, which means to say, these are not the only two forms of evidences. In fact, evidence, the phrase evidence is used in Indian Evidence Act in different places. For example, under Section 60, the term oral evidence is used. Under 61, documentary evidence used. 62, primary evidence. 63, secondary evidence. And of course, we have also come across various phrases that has been regularly used, such as best evidence, direct evidence, circumstantial evidence, corroborative evidence, derivative evidence, hearsay evidence, and so on. Therefore, considering all these things, we can safely say that there are several kinds of evidences in the trial which has to be led in the trial. However, two main evidence that is required is direct evidence and circumstantial evidence, or in other words, it is called as indirect evidence. Now, let us see who is a witness. Both in the, I would say either in the Evidence Act or Criminal Procedure Code, the definition of witness is nowhere defined. In fact, according to Black's dictionary, witness is the one who sees, knows, or vouches for something, or one who gives testimony under oath or affirmation in person, or by oral or written deposition, or by affidavit. In fact, Honorable Supreme Court of India, in the case of Madhu at Madhuratna versus State of Karnataka, reported in 2014 to Karnataka Law Journal at page 158, has attempted to give a meaning, assign a meaning to the word witness. The Honorable Supreme Court has held that the term witness means a person who is capable of providing information by way of deposing as regards relevant facts via an oral statement or statement in writing made or given in the court or otherwise. Therefore, we can say that a witness is a person who possesses first-hand information relating to the event. He can give a testimony as to what he has actually seen that is related to the fact that is to be proved in the court of law. And his testimony is considered as evidence. And even under the Evidence Act, Chapter 9 relates to the of witnesses, which in other words, Section 118 to Section 133 of the Evidence Act explains the person who may testify among other parameters. Whereas Sections 135 to 160 of the Evidence Act explains the manner in which the examination of the witnesses have to be conducted, the other aspects like the order of the witnesses, who has to first examine, how the cross-examination is to be led, what are the questions to be asked, and the role of the court. Friends, interestingly, if you notice Section 134 of the Evidence Act, this section does not prescribe any particular number of witnesses that is required to be produced in a case to prove a fact. This would be a bit intriguing. The Honorable Supreme Court in the case of Namdeo versus State of Maharashtra, reported in 2007 SEC 150, has said that it is clear that Indian legal system does not insist on plurality of witnesses. Neither the legislature nor Section 134 of the Evidence Act nor the judiciary mandates that there must be particular number of witnesses to record the order of conviction against the accused. Our legal system has always laid emphasis on value, weight, and quality of evidence rather than on quality, multiplicity, or plurality of witnesses. Therefore, it is clear that the courts can rely upon a single witness and can record its order, either by conviction or acquittal. It is not necessary that there should be several witnesses to prove the case of a prosecution. In fact, Section 180 of the Evidence Act states what exactly the term witness is, rather, who can testify. Who may testify? All persons, Section 118 of Evidence Act reads thus: all persons shall be competent to testify unless the court consider they are prevented from understanding the questions put to them or from giving rational answers to those questions by tender years, extreme old age, disease, whether of body or mind, or any other cause of the same kind. In the explanation, it is said that a lunatic is not incompetent to testify unless he is prevented by his lunacy from understanding the questions put to him and giving rational answers to them. Thus, as you notice, Section 118 of the Evidence Act permits practically all persons to be competent to tender evidence. However, the safeguard measures are incorporated, as I just read out, that a witness should understand what the questions put to him and he should be able to answer rationally. So much so, even a lunatic is also permitted to testify, subject to the condition prevented. I would like to read out the meaning of witness as stated in advanced law lexicon. It is stated that, rather, the meaning assigned here is the term witness in strict legal sense means one who gives evidence before a court, and in its general sense include all persons from whose lips testimony is extracted to be used in any judicial proceedings, and so includes deponents and officials, as well as persons delivering oral testimony before the court of judiciary. Even as per this law lexicon, all persons are competent to tender evidence, of course, subject to the conditions incorporated in Section 118 of the Indian Evidence Act. Now let us go to the types of witnesses whom we encounter in our day-to-day practice. As we have noticed in our day-to-day practice, there are infinite varieties of witnesses we meet in the court. This makes it extremely difficult for us to lay down any set of rules applicable to all of them. We cannot have a straitjacket formula stating that describing a particular witness. In fact, many a times in practice, in our trials, we have seen that no two witnesses are alike. They have to be tackled individually based on their own merits. There one interesting decision rendered by the Honorable Supreme Court in the case of Marwadi Kishore Paramanandananda versus State of Gujarat, reported in 1994, Part 4, SCC 549. The Honorable Supreme Court has attempted to assign a meaning to the type of witnesses, or summarized the type of witnesses and their evidentiary value. The Supreme Court has that there are three categories of witnesses, namely, 1, those that are wholly reliable; 2, those that are wholly unreliable; 3, those who are neither wholly reliable or unreliable. In the first category, the court has absolutely no difficulty in coming to the conclusion either way. It can convict or acquit the accused on the deposition of even on a single witness, if it is found to be fully reliable. Of course, if it is unreliable, there is no question the case of the prosecution can be thrown out. As regards the third segment is concerned, it depends on the quality of the evidence. In the light of the above categorization of type of witnesses by the Honorable Supreme Court, it is extremely important for us to know the type of witnesses we find in the criminal trial. In fact, in a criminal trial, we can categorize the witnesses based on their Section 161 statement, their relation to the victims or the prosecution, and we can also foresee what exactly they are supposed to come and tender their evidence. So, general categorization of important type of witnesses are as follows. First, let us start off with prosecution witnesses. Who are prosecution witnesses? Witnesses who appear on behalf of the prosecution to prove the case of the prosecution are generally known as prosecution witnesses. In our state, we refer to them as PW 1, 2, 3, that is prosecution witnesses. Second, defense witnesses. These witnesses are the one who appear on behalf of the accused to prove the defense or to rebut the evidence led by the prosecution. They are generally referred to as DWs, and the defenses have to be on par with prosecution witnesses, and there should not be any differentiation between them. Now let us see the actual type of witnesses who would come and tender evidences in the criminal trial. The first of the kind is eyewitness. As the name would suggest, this witness gives the testimony of the fact he has seen, what he has seen, where he was present, actually how the crime was committed, and what he has heard. So this eyewitness is the best evidence the court would rely upon. In fact, courts normally heavily relies upon the evidence of eyewitnesses to determine the case. He makes a very, very powerful impact on the court. It is extremely difficult to dislodge his evidence. In the case reported by our Honorable High Court of Karnataka, in Vishnu Narayan Moger, was a state of Karnataka, reported in 1996 Criminal Law Journal at page 1121, it is held that an eyewitness is one who saw the act, fact, or transaction to which he testifies. A witness is able to provide graphic account of the attack on the deceased can be accepted as eyewitness. In fact, many a times, convictions have been recorded based on the testimony of single witness. There is no rule of law or evidence which says to the contrary. It is not that there should be any number of many witnesses to prove a case. In fact, as the Honorable Supreme Court has already held, it is not the quantity of witness, it is the quality of witness. Therefore, relying on the evidence of single eyewitness, court can come to a conclusion. Next is independent witness. This witness is disinterested, either in the case of the prosecution or in the case of the defense. This witness generally speaks the truth. He just testifies to the facts as and is, with regard to the aspect of what he has seen or heard, without favoring anyone. In a criminal trial, the evidence of the independent witness is extremely crucial, especially in cases of search and seizure, last seen together, and in many other instances. Prosecution is expected to produce the evidence of independent witnesses. In fact, there have been many acquits have been recorded for non-production of independent cases. The Honorable Supreme Court, in a case reported in 2009 Criminal Law Journal at page 4123, has held on facts, especially in the case of NDPS, where the role of independent witnesses is extremely important, has held that when serious allegations are made against the police officials, recovery of contraband in the presence of independent witnesses assumes importance. And in that case, the conviction was reversed and the accused was acquitted in view of the fact that the prosecution had not produced the independent witness. Next comes a child witness. Friends, perhaps child witness is the most dangerous witness we encounter in our practice. With that tender age and innocent face, they can wreak havoc in the defense theory. And courts are all extremely sympathetic to these little ones. For a defense counsel, cross-examining a child witness is a Herculean task and at times is a nightmare. A lawyer just can't use his histrionics of the child and incur the wrath of the court. In fact, recently, while I was cross-examining a child of 8 years, in a POXO case. He gave me an harrowing time. He also reminded me of Dennis the Menace. I was also blasted by the court for trying my usual stuff to intimidate the child. Having said that, friends, children are most untrustworthy class of witnesses. They often think fiction or their dreams as reality and tend to repeat it as if it is their own knowledge. And apart from that, children or a child witness is easily amenable to tutoring and being influenced by others. As example, for their parents or whoever, they tend to repeat what they are taught in the court of law. They also enact the facts that even they do not know or understand. They will do this probably to please their tutors, for the reward, or for the fear of being punished. Hence, it is the duty of the court to record the competence of credibility of the child witness as to satisfy itself whether the child understands the duty of speaking court, the child understands as to why it has come to the court, what is he supposed to answer, and why the answer should be given. And the court also has to determine that whether the child has sufficient intelligence to answer the questions rationally. When the court is satisfied that the child is capable of giving such evidence, then there is absolutely no bar for the child to tender evidence. In fact, the child can be treated like that of any other witnesses, including that of an adult witness. As you see, under Section 118 of Evidence Act, there is no age prescribed for a witness to tender evidence. All witnesses are competent. Therefore, the child is also competent from giving evidence in the court of law. Of course, subject to the satisfaction of the court that the child has got capability to do so. Another peculiar feature is, even in the absence of oath, the evidence of the child can be considered. As because the oath is concerned, as back as in the year 1952, the Honorable Supreme Court of India, in a case reported in 1952 AIR SC 54, has held that every witness is competent to depose unless the court considers that he is prevented from understanding the questions put to him or from giving rational answers by the reasons of tender age, extreme old age, disease of body and mind, or any other cause of the same kind. It is desirable for the judges to maintain, always record their opinion with regard to tender evidence. Of course, there is no bar under law to accept the evidence tendered by the child. Now comes prosecutrix. Perhaps this witness, prosecuting witness, is cross-examining her is most difficult and painful for a lawyer, because in the back of our mind, we know that this poor witness is a victim of rape, sexual abuse, or sexual assault. In the back of our mind, we are also aware that this poor lady is before the court, detailing her ordeal, and then the stigma attached to it. She has to face all these things. So, in the light of this, cross-examining this poor soul is extremely difficult. But however, as a defense lawyer, we have to cross-examine. Thankfully, law and judiciary has ensured to make this witness more comfortable by way of creating women-friendly courts, in-camera proceedings, and also censuring the counsel's lawyers from asking certain uncomfortable questions. Friends, as regards the prosecutrix evidence is concerned, generally it is held that the victim of rape will not implicate an accused falsely for having committed sexual assault on her. More so in our Indian social structure, no lady will come into the public and say that she has been sexually assaulted. Further, the court also, in the case of sexual assault, will not generally insist upon corroboration or independent witness. By and large, the witness of the sole witness of the prosecutrix is sufficient if it is found reliable to convict an accused. The Honorable High Court of the Honorable Supreme Court in the case of Asaram, that is reported in 2005-13 SEC at page 176, has held as under, which I would like to read this. The evidence of prosecutrix is more reliable than that of an injured witness. The testimony of victim of sexual assault is vital, unless there are compelling reasons which necessitates looking for corroboration of her statement. The court should find no difficulty in acting on the testimony of victim of sexual assault alone to convict the accused. In fact, in another celebrated case, the Honorable Supreme Court in the case of Bharwada Hijri Bhai versus State of Gujarat, reported in 1983 Criminal Law Journal at page 1096, as held as under. In the Indian setting, refusal to act on the testimony of a victim of sexual assault in the absence of corroboration as a rule is adding insult to injury. Why should the evidence of a girl or a woman who complains of rape or sexual molestation be with aid of spectacles, fitted with lenses, tinged with doubt, this belief or suspicion? To do so is to justify the charge of male chauvinism in the male-dominated society. It is conceivable in the Western society that a female may level false accusations as regards sexual molestation against the male for several reasons. The statement is generally true in the context of urban or rural society. It is also by and large true in the context of sophisticated society. Only very rarely can one conceivably come across an exception or two, and the two possibly from amongst the urban elites. So friends, as a word of caution or based on humanity, I would request you to be very considerate while cross-examining this poor soul, the prosecutors, rape victim. Of course, there are a large number of cases where males are being falsely implicated. But having said that, we should be extremely considerate as regards the prosecutors while we are cross-examining. Next is one of the most dangerous witness, who is the injured witness. This injured witness is a combination of many witnesses. That is, he is an eyewitness, he is a victim, he is an interested witness, he is a natural witness, and also he is a witness inimically disposed against the accused. He has a whole agenda of ensuring that the accused is convicted. Hence, the chances of this injured witness falsely implicating the accused cannot be ruled out. However, having said that, the evidence of the injured witness cannot be ruled out. In this regard, the Honorable Supreme Court, in a case reported in the case of Mayor Sidha versus State of Gujarat, reported in the year 1985, Part 1 SEC at page 200, has held that where a witness to the occurrent was himself injured in the incident, the testimony of such witness is generally considered to be very reliable, as he is a witness that comes with an inbuilt guarantee of his presence at the scene of crime. Therefore, dislodging the evidence of this injured witness is extremely difficult. We should be very, very careful, and we should know the motive as to why he has to falsely implicate the accused. Majority of the convictions are recorded merely based on the evidence of injured witness. And another type of witness we come across generally is interested or partisan witness. I can say most of the witnesses fall within this definition, because most of the witnesses are prosecution witnesses. They are invariably interested in the case of prosecution. They would be by and large the friend or relative of the victim, or they may be inimically disposed against the accused or interested in the case of the prosecution. They are generally biased. They are interested to secure the conviction of the accused. In several cases, it is seen that these interested persons has their personal agenda. They have an interest in the outcome of the trial, which is that outcome invariably is the conviction of the accused. Interestingly, the Honorable Supreme Court, in the case reported in Takdir Samsuddin Sheikh versus State of Gujarat, 2011, Part 10 SEC, at page 158, as held, the meaning of the term interested postulates that the witness must have direct interest in having the accused somehow or the other convicted for some other reasons. It is settled position that the evidence of interested witness is highly unreliable and the same cannot be accepted without corroboration. In fact, the same view is also held by the Honorable Supreme Court in several other cases. And the next class of witness we find is material witness. See, many types of witnesses fall under this category. They may be eyewitness, chance witness, punch witness, trap witness, injured witness. These are all can be considered as material witness. Essentially, material witness is a witness who would unfold the case of the prosecution, which is significant enough, which has got a bearing, great amount of bearing in the outcome of case or trial. In fact, the courts also would love to see the prosecution to produce the material witness, as they are extremely essential to give the evidence. Several acquittals have been recorded, and the case of the prosecution has held to be fatal by the non-production of the material witnesses. Therefore, it is the duty of the prosecution to produce the material witness, as they also would help the court to come to a fair and just decision. The next class I would like to say is that the relation witnesses, as the name would suggest, these are the witnesses who are related to the victims. Again, these witnesses are extremely dangerous. They are invariably interested witnesses. They are interested in the outcome of the trial. They are interested to see that the accused is convicted because they are related to the victim in whatsoever manner. Hence, their evidence had to be scrutinized more carefully and critically, and their evidence should corroborate with other circumstances and evidence of the case. Next witness we come across is hostile witness. These guys are everywhere in the trial. These hostile witnesses are double-edged weapon to the case of the defense. Generally, hostile witness are the one who would generally rescind to the statements which they have given or might not have given under section 116 of the CRPC. During the trial, while tendering evidence, they may not support or they may turn hostile to a particular portion of their statement or to a circumstance or to the entire statement which they have given to the police on section 161 as such. The danger here is the Honorable Supreme Court in several cases has held that the evidence of the hostile witness cannot be totally thrown away. It cannot be rejected in totality. The evidence of the hostile witness can be considered to that portion where they have given admissions. And in few instances, after once the hostile witness is declared as hostile, the prosecution would invariably cross-examine them. And in that, during that cross-examination, they may turn around and support the case of the prosecution. So in view of this, the Honorable Supreme Court in various cases held that only that portion of the witness where they have turned hostile can be rejected, but the others can be accepted. The Honorable Supreme Court in the case of Rajendra versus State of UP, reported in the year 2009-13 SEC 480, has held that the testimony of hostile witness may not totally be rejected, but it is subject to close scrutiny. Portion thereof, which is consistent with the case of the prosecution or defense, may be accepted. Merely because a witness has turned hostile, his evidence cannot be rejected in its entirety. If a portion of his testimony is corroborated by other evidence, the same can be relied upon. Friends, in my practice, I have seen on many occasions, lawyers just do not cross-examine these hostile witnesses, merely on the ground or assumption that their evidence is not considered. Friends, this is extremely dangerous situation. because as the Honorable Supreme Court has held that a portion of the hostile witnesses also can be considered. In fact, in several cases, I have seen that the evidence of the hostile witness has been taken into account for conviction. Hence, please be very careful. Please do not treat the evidence of hostile witness casually on the ground that they have turned hostile. See where they have turned hostile and ensure that you would cross-examine them. The next witness in our scheme is the chance witness or natural witness. As the name would suggest, that chance witness is a person who is in the scene of offense just by chance or by coincidence. It is not my design. But however, this chance witness has to prove in the court that he was there or at the time of the offense committed by chance and not with any premeditation. This witness is also a natural witness. Many times there will be a confusion as to how to treat the witness, whether it's a chance witness or a natural witness. Many times a chance witness can also be a relative or a friend of a victim who or maybe inimically disposed towards the accused. However, the testimony of the chance witness cannot be rejected for these reasons. The Honorable Supreme Court, in the case of Rana Pratap versus State of Haryana, a report in the year 1983 Criminal Journal, 1272, as held, if a murder is committed in a dwelling house, the inmates of the house are natural witnesses. If a murder is committed in a brothel, prostitutes and paramours are the natural witness. If the murder is committed on street, only passerbys will be witnesses. The evidence of street hawker and street vendors cannot be discarded or viewed with suspicion merely on the ground that they are chance witnesses. Therefore, the evidence of chance witness can cut across both the ways, in favor of the prosecution or as well as in favor of the accused. Next witness I would like to say is that of inimical witness. As the name indicates, this guy is extremely dangerous because he is inimically disposed against the accused. He has animosity against the accused. His only intention would be when he comes to the court, his intention would be to ensure that the accused is convicted because there is an animosity. This animosity between the accused and the witness can act as a double-edged weapon, which can cut both the sides. It may be instrumental for the witness to falsely involve the accused, or it may be a motive for the accused to commit the offense on the witness. In this regard, the Honorable Supreme Court of India, in a case reported in AIR 2001 SC at page 3173, Anil Roy versus State of Bihar, as held, the existence of animosity may in some cases give rise to the possibility of the witnesses exaggerating the role of some of the accused of trying to rope in more persons as accused for commission of crime. However, mere existence of animosity cannot be made as a basis to discard or reject the testimony of eyewitnesses. The next witness is official witness. And also I would include police witnesses also into this group. Official witnesses are generally public servants who have conducted their duties in the course of discharging their work. Official witnesses are expected to be independent. They should not have any motive, or they should not have any motive against the accused. However, having said so, the official witnesses, including the police who would have investigated the case, laid a charge sheet, have a great interest to see to it that their investigation or the witnesses who tendered the evidence would end up successfully, that is, conviction of the accused. Therefore, this official witnesses and public witnesses evidence should be treated very carefully. Next witness is the punch witness. As you are aware, punch witness are extremely important for a criminal case. These are the witnesses who would have witnessed various stages of investigation, such as search and seizure, arrest of the accused, or securing some material from the accused or from a place. These witnesses are extremely important to unfold the case of the prosecution. The next witness is a very interesting witness, who is a rustic witness. The rustic witness, as the name indicates, he can also be an illiterate witness. He is not educated. And generally, he comes from a poor strata of the society. As compared to educated witness, he is not expected to remember every small detail of the incident and the manner in which the incident has happened. And the next class is expert witness. As you are aware, expert witness is a person who has a specialized knowledge or skill in a particular field. He is qualified to present his opinion on a fact that is required to be co-proved in the court of law. He is not a witness of fact, but he only provides scientific opinion on a technical matter. All these years, probably we had very few group of expert witnesses, such as handwriting expert or doctors or fingerprint experts. Now, as the law has grown, we have so many experts who are able to provide their opinion to solve a case, to help the court to arrive at a fair and fair deliverance of justice. The other witness is a trap witness. This trap witness is a person who generally induces or lures the accused to fall into a trap. By and large, in the prevention of corruption cases, the trap witnesses are the trap witnesses were coming. However, there is a confusion to treat whether these trap witnesses are accomplices. But it is also said that they may not be accomplices. These trap witnesses are generally interested to secure conviction. Therefore, their evidence have to be corroborated by way of corroborated with other evidences. The other witness where we come across is stock witness. Generally, police will have a bank of persons who invariably come and tender evidences in various cases, in multiple cases. By and large, we will find these stock witnesses as punch witness. And another set of witness we find is approver, accomplice. Section 133 of Indian Evidence Act has provided this witness, accomplice. As the name would say, that this accomplice is a person who is involved in the commission of crime along with the accused. Therefore, this witness is also a very dangerous witness to the case of to the defense, since he would like to get himself out of the accusation and implicate the accused. However, the courts also would not generally accept his evidence without there being any supporting other evidence. Another important witness is a dead witness. I'm sure you'll be surprised how a dead witness. Many a times, the witness whose statement is recorded or who is a witness may die before his deposition could be recorded. This does not mean that the prosecution case has to be dropped. The evidence, rather the circumstance spoken to by the dead witness can be considered by way of corroborating when it corroborates with the available evidence. Therefore, when a person dies, the case does not die. Friends, having class, this is the very few type of witnesses where I could summarize. There are many, many, many more, and they are developing. I said that I would suggest that we should know the psyche of a witness. Of course, we cannot play Dr. Sigmund Freud. The Honorable Supreme Court, in case of Marwadi Kishore Parmanand, reported in the year 1974, SEC 549, has held that different persons react differently in different situations and circumstances. No hard and fast rule of universal application with regard to the reaction of a person in given circumstances can be laid out. Most often, when a person happened to see or come across a gruesome and cruel act in perpetration within his sight, then there is a possibility that he may lose his equilibrium and balance of mind and remain as a silent spectator. It is also held that said that every witness is an editor. He would like to narrate, tender, testify the way he wants. Therefore, we should know the psyche of few of the witnesses. You will get forgetful witnesses in your experience as a trial lawyers. You have seen a witness keeps on forgetting. At least he will act as though he will forget. This will put the cross-examiner in a bit of confusion. And there is another dangerous witness, bullying witness. It is generally regarded that we lawyers bully the witness. It is not so. Nowadays, with the advent of internet, with various other source of knowledge, this few witnesses would come prepared to bully the lawyer. They will say, "Na nodkotene lawyer na ivattu." This is the very dangerous witnesses. We have to deal with them. And you have got witnesses who gives evasive answers. You have witnesses who are liars. They keep on lying. Whatever suggestions we put, they lie. And then we have got these smart witnesses. These smart Alex think that they are mini lawyers. Probably they have read a bit of law also here and there and try to outsmart the witnesses. So we should be careful with these witnesses also. I mean, these are all the few witnesses where we should be careful of and we know. With this, I would like to close my session. And before closing, there is one particular decision of Honorable Supreme Court in the case of State of Kerala versus Rashid, where the Honorable Supreme Court has, in the year 2018, has laid down a procedure for the trial court to adopt as regards the conduct of, to record the witnesses in the trial. So we should be we should aware of these guidelines we are laid down by the Honorable Supreme Court. Thank you. And you have to excuse me in the event if I am a bit fast in my rendition. Thank you, Trivikram.
Thank you, sir, for our very, very informative session. Indeed, a intriguing session. So with your permission, can we now move on to the Q&A session, sir?
Sure, of course.
Yeah. A small announcement because of the exhaustive nature of today's topic. I request all the learned colleagues to restrict the question to today's topic only. All right. Mr. Umesh already has raised this question. Mr. Umesh, I have unmuted you. You can go ahead with your question.
Hi, sir. Good evening, sir.
Good evening, Umesh.
Yes, sir. This is Umesh, advocate here.
Yeah.
I have a simple question. I have a little doubt in respect of dead witnesses, sir.
Ha. What is
dead
the
witness? Can
what
you
is
explain
the,
once again, sir? Dead witness.
See, for example, in the case of a rape, the victim dies for whatsoever reason.
Sir.
Only because of the reason that she is dead, the case of the prosecution cannot be thrown out. We can always, the prosecution always place several other circumstances to prove the case against the prosecution. Therefore, here where it is used, the name as a dead witness is used.
Yes, yes. Thank you, sir.
Before we go ahead with the next online question, we have offline question, sir. What is the importance of character witness in a criminal case?
See, in a criminal case, in my little experience, character witness may not play much of a role because this character witness by and large would tender evidence as regards the character of another person. Therefore, character witness may not play such an important role in the criminal case.
All right, sir. Thank you. So Praveen Kalapa has a question. Yes, Mr. Praveen.
Very good evening.
Good evening, Praveen.
I had a doubt regarding witness, the testimony witness with respect to 376 cases. As you said, there are many instances where male have been falsely implicated.
Correct.
I had come through a case wherein the vital evidence for that case was a video clip. As per the statements and the evidence led by the victim, that particular video was recorded on some other date and not on the date what she had alleged in her complaint. But neither the court nor the investigation officer had put up his mind to send the particular video clip to the FSL. And the court insisted only on her statement, and it came forward to convict the accused. The saddest part is, finally, the accused had to yield to her demand.
See, this question by and large relate to the appreciation of evidence. It is not the question where we are dealing with today type of witnesses. But having said that, in a recent Supreme Court, in a recent decision, the Supreme Court has held that the video clipping can be considered as a material evidence. Therefore, non-production, rather non-utilization of a video clip may inure to the benefit of the defense.
Thank you, sir. Mr. Rajesh A. He has a question. Yes, Mr. Rajesh, you will have to unmute yourself. I've given you the option. Sir, quickly. I've given you the option.
You proceed with the other, sir.
All right. You raise your hand. All right. Okay, sir.
Okay.
Can we have the next question, please, online? Quickly. Can we have the next question? Yes, Mr. K.S. Ravi Kumar has a question. Sir, I have unmuted you. Go ahead.
Sir, my name is K.S. Ravi Kumar from Raichur Bar Association, sir.
Hello, Mr. Ravi Kumar.
Sir, usually when any incident occurs, sometimes the victim doesn't lodge a complaint before the police station. It is some other person who lodges a complaint written. And where the complainant witness has not been examined by the court, whether there is a benefit for the defense to acquit the accused.
See, there again, this is an appreciation of evidence question. However, the law is very clear. Anyone can set criminal law into motion. It is not that the only victim should say. Therefore, that first part is there is no bar for anyone to set criminal law into motion. The second part, non-examination of a complainant. Again, it depends. As I was telling, as regards the dead witness, if the witness of the complainant is extremely important, and if it is the only witness that will prove the case of the prosecution, then non-examination of such a complainant witness will inure to the benefit of the defense.
If the only complainant witness is essential on that part, that may be part benefit to the defense.
Exactly.
But otherwise,
if there are other surrounding circumstances,
circumstantial evidence,
yes,
and
then, without
there
there being a complainant's evidence also, the court can proceed with the conviction.
Yes. Sir, any citation with regard to this, sir?
That you can, we'll discuss it later.
Okay, sir. Okay.
There are lot many citations on that. Lots.
Okay, sir. Sir, if I have your number, I want to contact.
Yeah, Mr. Trivikram will help you out on that.
Okay, thank you, sir. Thank you, sir.
Mr. Chandrakant Raju, you can go ahead with your question. I have unmuted you. Sir, quickly, Mr. Chandrakant Raju, I have unmuted you. All right, can we have the next question, please? Can we have the next question? Yes, ma'am, I have unmuted you. Mrs. Ramsa, I have unmuted you. Yes. You're not audible, ma'am. You will have to unmute yourself.
Can you hear me, sir?
Yes.
Yeah.
Good evening, sir. Good evening, Mahesh, sir. It was an excellent thing. It was like an episode for advocates like us to conduct the trial in the trial court. My question is, in the case of rape case, when the witness becomes a victim, becomes a hostile, and the accused is being acquitted, is there any possibility to take this matter to the appeal court, sir?
Of course, appellate court is always open. Appeal is always open. Even now with the amendment, a victim also can file a appeal. So there is absolutely no bar for.
So victim is hostile, sir.
No,
she became a hostile.
The victim herself turns hostile. And hostile, precisely. And in the event if there are no surrounding circumstances would in turn would prove the guilt of the accused, despite of accuser, rather victim turning hostile, then you may have a very weak case.
Okay, sir. Okay. Yes. In murder case, sir,
Huh.
how strong is the circumstantial evidence, sir?
See,
in murder case, how strong is the circumstantial evidence, sir?
Circumstantial evidence is extremely strong in murder case, provided that the link, all the links of the chain is together. It has to be as a whole. There cannot, not even a single link should be broken. Then only the circumstances will prove the guilt of the accused.
Thank you, sir. Thank you, sir.
Thank you, sir. In continuation of question posed by Mrs. Ramsa, what if the victim is hostile? Apparently, there is one or two witnesses who have supported the case of the prosecution.
See, as I told you, the Honorable Supreme Court has said that mere a victim turning hostile will not inure to the benefit of the accused. In fact, the best example is the dead witness. The witness is not at all there, but still conviction can be recorded, provided that there are several other evidences which support the case of the prosecution. Therefore, in the light of the same, even if a victim turn hostile, still prosecution can prove its case.
Thank you, sir. Mr. Naresh has a question. Yes, sir. Go ahead.
Yeah,
Good evening, Mahesh.
good evening, Naresh. How are you?
It's very nice. It's a very nice program. I enjoy very much.
Thank you.
And only one thing I request you to kindly throw some light on the evidentiary value of the witnesses. Suppose if there is things with respect to omission, contradiction. Thank you.
Probably we can have it in a next session, because as I told you, I am not on the evidentiary value or the appreciation of evidence. Today, my session allotted was only to give the overview of the type of witnesses we generally encounter during the criminal trial.
Done. Thank you.
Yeah.
Thank you. Nice
Thank
meeting
you, sir. Whoever it is, Mr. Redmi. So I have unmuted you. Yes, sir. Go ahead with your question. You have raised your question, Mr. Redmi. Whosoever is using the Zoom ID with the name Redmi, please go ahead with your question. Quickly. All right, Mr. Narsa Reddy, I have promoted you to the panelist, and you can go ahead with your question. Yes, Mr. Narsa Reddy. Sir, quickly. Mr. Prabhu Swami, I have unmuted you. So whosoever, my kind request to all of you is, when you raise your question, please go ahead with your questions. We have number of raised hands, and then people become silent. We don't want that. Yes, Mr. Prabhu Swami, please go ahead. Sir, you will have to unmute yourself. You're not audible. Sir, I have given you the...
Hello, sir.
ಕೇಳಿಸ್ತಾ ಇದೆ ಹೇಳಿ ಸರ್.
ಸರ್ ನಂದು ಕ್ವಶನ್ ಏನಂದ್ರೆ, ಈ ಪೋಸ್ಕೋ ಆಕ್ಟ್ ಅಲ್ಲಿ ವಿಕ್ಟಿಮು ಅಷ್ಟೆಲ್ ಆಗ್ತಾರೆ, ಅದರ್ ವಿಟ್ನೆಸ್ ಅಷ್ಟೆಲ್ ಆಗ್ತಾರೆ. ಓನ್ಲಿ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದೊಂದು ಬೇಸಿಸ್ ಮೇಲೆ ಕನ್ವಿಕ್ಷನ್ ಕೊಡ್ಬೋದಾ ಅಂತ?
ಕೊಡೋಕ್ಕಾಗೋದಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ
164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ, ಅದನ್ನ ವಿಡಿಯೋ ರೆಕಾರ್ಡಿಂಗ್ ಮಾಡಿರ್ತಾರೆ.
ಇದಿರಬಹುದು. 164 statement cannot be a substantive piece of evidence when it is not supported with corroborative piece of evidence. So merely on the statement of 164 kodlik barodiಲ್ಲ, in my opinion.
Thank you, sir.
Thank you, sir. Mr. Redmi, again you have raised your hand. I have unmuted you. Yes, Mr. Harish. Yes, sir. Please go ahead. I have unmuted you.
Good evening, Mahesh.
Good evening, Harish. You always come out with wonderful questions.
Based on the witness protection scheme of 2018,
correct.
Do you think that has served its purpose, and whether it has been encouraging for bystander witnesses or other witnesses to come to the court and tender their evidence?
No, it is not.
Then what is the use of the scheme?
Scheme is there, law is there. Despite of the law being there, you have got a lot of offenses being committed. So it's analogically as simple as that. Scheme is there in 2018, based on the Honorable Supreme Court's, especially because of this Asaram's case. Witness Protection Act came, and even the rights
There's
of
no act as of now, but only the scheme is there.
Therefore, right of witnesses was also delineated. But having said that, it has remained there. But still, with this active promotion of right of witnesses or with protection scheme, there is certain benefit to the witnesses given, and the threat to them is to certain extent has been reduced, minimized.
Thank you.
Thank you, sir. Mr. Ishwar Nayak, before we commence the session, you had informed me that you have a question, and I see you online. Do you want to ask your question? I have unmuted you. Any more questions before we wind up the session? Yes, sir. Prasanna DP. Yes, sir.
Hello.
Prasanna.
Hello.
Yes, Prasanna.
Someone is asking question. Hello.
Hello.
Good evening, my sir. Good evening.
Good evening. Good evening.
Sir, effect of shadow witnesses in case
Sorry?
of shadow witnesses in case of trap case. When complaint is turned hostile, effect of shadow witness in the case of trap in corruption matter. If the
You want to say that what is the effect if complainant turns hostile or shadow witness turns hostile?
Complaint turn hostile.
All right. See, in many cases, complainant have turned hostile. But if the basic allegation of demand and acceptance is proved, and thereafter the other tests, trap tests, phenomenal test is proved, then despite of the complaint turning hostile, conviction has been recorded. Because as I was saying, that sometimes there's a confusion. There are two schools of thoughts. Whether complainant who lures the accused into commission of crime is treated as an accomplice. Therefore, in the light of the same, complaint merely turning hostile may not inure to the benefit of the defense.
Thank you, sir. Mr. Ishwar Nayak, ನೀವು ಪ್ರಶ್ನೆ ಕೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ, ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿದ್ದೀನಿ, ತಾವು ಕೇಳ್ಬೋದು ಇವಾಗ.
Hello, sir. You are hearing me, sir?
Hearing.
Sir, recently you have read in newspaper also, you have heard in TV also. One lady, she is employer, and employee was working with her, sorry, and she filed a case against that employee that she invited him, and he raped her, and then she filed a case in court. In lower court, the accused was convicted. Then he challenged in a high court. Perhaps you might have remembered this case, sir. And in high court, the judgment was reversed, whatever lower court has given. And this type of evidence what prosecutor is giving, why simply relying by the court and giving judgment and making the accused to undergo all types of what do you call he has to undergo all types of mental agonies.
I know. Yes.
Is it not right on the part of lower court to take the evidence properly and give judgment, sir?
Sir,
instead of going to high court and challenge and get reverse the judgment.
This is a male chauvinistic question, and I don't want to incur the wrath of the fairer sex. But having said that, Mr. Nayak, what happens is the appreciation of evidence by the trial court would be on a different scale, and the appreciation of evidence in the appellate court is also on a different scale. So please remember that if a trial court either convicts or acquits an accused, then in the appellate authority and appellate court, the High Court or the Supreme Court may, on different consideration or appreciation of evidence, can reverse this same. So hence we cannot say that the trial court has committed an error by convicting or acquitting. That is there. Why would you say only for the rape cases? Any other case, murder case or 307 case or 138 case, every other case, you know. So let us not fix it or freeze it only on the rape cases.
Thank you, sir. Mr. Chandrasekhar Ake, you can go ahead. I have unmuted you. And Mr. Chandrasekhara K, I have unmuted you. You have raised your hand and I have unmuted you. I think that's about it, sir. Before we conclude, last time, if anybody has a question, please raise your hand. All right. Thank you so much. Sir, thank you so much for this informative session. On behalf of Advocates Association Bengaluru, I extend my heartfelt thanks to you. Thank you so much.
Thank you. Thank you very much. I am really privileged to be amongst you in this session. And as a parting shot, my only request is that we lawyers cannot be in one place. And this COVID has ensured that we are within four corners of the world. So please stay safe. That's it about it. All the best. And thank you for inviting me, Mr. Trivikram and Advocates Association as well. I will log out now.
Thank you so much, sir. With your permission, we will be logging off.
Yes. Thank you.